This conference will now be recorded.
Dun, dun, dun. Again, welcome everybody to Knights of Columbus Fraternal Benefits Evening. I'm Dan Garrigan. I'm your field agent with the Council 11922. It's our pleasure this evening to be able to host Jim Seidel and Sonia Rustisi. They're both with the Seidel Law Offices, and we're going to learn a lot about how to protect your family from basically beyond the grave, or if you can't speak for yourself, or there's a lot of things that can happen between now and the great beyond. And so we want to make sure that you and your family are protected. So again, quickly, the Knights were established by Catholic priest, Father Michael J. McGivney, back in 1882. For the main purpose of protecting the family, either in disability or in death, making sure that the family had resources in which to continue on with the way they are, with the lifestyle they've become accustomed to. We're going to learn a lot tonight about how to, how to prepare for that. What do you need to do? What do you need to do to make sure that you don't leave something for your family that they have to, then all of a sudden it becomes a major burden for them. I will tell you, we are going to be not only recording this, but we're also, if you need the slides, we can also get you the slides if you need those. We're going to, there are a lot of resources here. My job, I always feel, is it doesn't matter what you know, what I know, it just matters what I care about you as a client. And I want to make sure that you and your family are being taken care of. So as a value-added service, we're going to be going through how estate planning, wills, powers of attorney, trusts, how all that is put together, along with the financial products that are available to you through the Knights of Columbus, that we're going to, and how we can help you and your family. So there's a lot here, and we're already hearing. We just heard one of the members here whose father is in a nursing home, and they're having to go through this. They're having these hard decisions that have to be made or have been made, and it's tough. It's heart-wrenching. It's gut-wrenching. Some of the stuff that you have to go through, and why would you want to put your family through these kinds of decisions without a plan? Okay, so there's a lot we're going to be going over, and without further ado, I'm going to move it back over to Jim and Sonia, and they'll go ahead and begin.
You want me to take it from here, Sonia?
Yeah, Jim, are you going to introduce the law firm, and what do you want? Go ahead and start.
Yeah, okay. So I'm the principal of obviously of the James P. Seidel Law Offices. I want to tell you, everybody attending this is really, I think, is a very special webinar. I mean, we have worked very, very hard on these slides. They're the result of 25 years of intensive development. Even for this program, I deleted almost a half a dozen, added another half a dozen slides. I think you're going to really enjoy this. This is really going to be, part of this is a sales pitch. We would love to get your business, but the other is we want to make sure that you can walk away and say, even if we don't do business with the Seidel offices, we got some good information out of this, and I will guarantee you that you're going to get information that's going to be very valuable to you for now and in the future. Let me just start out with a little war story. I have a brother, Knight. I've worked with them for many, many years, a Maryland client, and notwithstanding that, they didn't update their documents. And last Friday, I get a frantic call from the wife, and she says, my husband is essentially almost comatose, and we realize our power of attorney is no longer acceptable to some of our institutions because it's been updated. Maryland has a new revised power of attorney. So, so we had to move into that. We got everything to her very quickly. Today she calls in a panic and says, well, you know what? He can't even sign the documents anymore. Now what? Well, so we're hand holding them through the process. There is a way you can get documents signed even if you are not capable of signing, and even though you are as long as you have enough cognition to realize what you're signing. So one of the reasons people come to these workshops is to avoid that scenario, because who knows, maybe the bank will not find this scenario acceptable, and then what do we do? We basically then have a pretty serious legal problem in our hands. Anyways, the main presenter tonight will be my associate, Sonia Ristici, who is going to take over, and she will pause after every slide to give me a chance to do a little color commentation, like kind of like NFL. You've got a broadcaster, and then you've got a color commentator. That's going to be me.
Right.
And so, Sonia, take her away.
Well, thank you, Jim, and thank you, Dan, for that great introduction. And so welcome everyone to our estate and business planning webinar, hosted by your Knights of Columbus Field Agent, Dan Garrigan, who's with us here tonight. And he's going to be, in a little while, he's going to be talking about why insurance products are so valuable to supplement your estate plan documents to help protect your assets from those extended care costs. And he'll talk about that in a little bit. Now, if you like anything that we have to say tonight, if you like what you're hearing, all you have to do is call this number. On this first screen, we have our telephone number and our email for the law firm. And if you'd like to have a meeting with one of our lawyers or paralegals to discuss, talk about estate planning, your estate planning and options, we would love to schedule an appointment with you. We have offices throughout Virginia, Maryland, and DC, and we are able to do virtual meetings now due to the virus. So would be happy to hear from you. Jim?
Okay, you can go to the next slide. Go ahead.
Wow, why is it not going? There we go. Sorry about that. All right. So a little bit of information about Attorney Seidel. He started our practice, this is a second generation practice. His father started the practice in 1941. So the practice has been around for quite some time. Jim has been an attorney since 1980, and we concentrate solely in estate and business planning. Jim is licensed in Virginia, Maryland, and DC, and he is a member of the National Network of Estate Planning Lawyers, which is an organization that has probably the best lawyers in the country, and we're able to pass that knowledge of information down to our clients because of that. Jim is also a past Grand Knight. A little bit of information about myself.
Well, let me just add something there. I want to say something about the National Network. Although I'm a solo practitioner in a sense, with the National Network, there's about 350 law firms, and we've all formed our own limited liability company. It's located in Indiana, and we have this incredibly great mainframe computer system that we keep all of our documents up to date. And every 30 days, our documents are revised to show them the most recent changes in the laws as inputted by these 350 lawyers. And should I pass on and Sonia is not there to take over, you're going to be connected, if you do business through our office, with those other 350 law firms. And there's about, I think I last inventory, about 7 of them are in this area, and so they will take over. They're not as good as me, but they're pretty damn good.
Yeah.
Okay,
well,
so take it away.
That's right, Jim, and thank you for going into the details about that wonderful network. So we're so happy to be involved with that organization. Just a little bit of information about myself. I've been involved in this area of law for over 20 years. I've worked for several lawyers and law firms in this area. All those law firms specialized in probate administration or estate and trust administration. I also worked for a couple of banks where I served as a bank trust officer, where the bank was named as trustee and executor of wills. So I managed that. Currently studying for the Virginia bar. So we have a pretty sad statistic here, a graph. There was a university not too long ago that did a study, and they determined that 3 out of 4 Americans die without proper estate planning. So I tend to think that, you know, if you don't have a proper estate plan in place, that means that the government or the courts are going to be managing some aspect of your life before you die or after you die, because you haven't properly planned and made sure that your loved ones could handle those things for you. So we're going to see that there's the before death and the after death planning, and it's so important to have a plan in place for that. Now, we have some handouts available for you. To get a copy of one of these handouts, all you would need to do is call our office there. We've provided the telephone number or the email address. We have a nice introductory booklet that goes into the details between the differences between living trusts and wills and the importance of medical directives. You can get a copy of today's slides. If you'd like to meet with a member of our staff about your estate plan, you'll be given an evaluation and sign-up form. And if you do sign up for a meeting, you'll be given a 5% discount on your fee.
So as I said earlier, we would love to get people to come to us to do business, and these are sort of some incentives to give our office a contact. These are good information. The introductory booklet is a very nice summary of estate and business planning. And the evaluation sign-up form will give you an opportunity to ask for an appointment with our office. Our appointments are no fee. The first one is no fee or obligation. Okay, Sonia?
Right. Thank you, Jim. And yes, we're going to go into the estate planning process here in tonight's discussion, so you'll find out about what our procedure is for meeting with you. This is an example of what you can expect the seminar evaluation form to look like when you get that from our staff. So as I said earlier, Dan Garrigan, your Knights of Columbus field agent, is with us tonight, and he's going to be talking to you about the importance of using insurance products to supplement your estate plan documents. The Knights of Columbus puts out this wonderful personal planning booklet, and you can get that from Dan. And I think that if you fill that booklet out in advance to a meeting with Dan, that booklet is going to give him, after you've completed it, give him a wealth of knowledge about where you and your family are at, and help him come to some conclusions on what type of products will be best suitable for your family. So here is his contact information. Okay, so want to take a note of that. So here we have a definition for estate planning. Okay, I think we've done a really good job of providing a definition of what is an estate plan. We've got it divided up into 3 different statements. The first statement really deals with that before death planning, that you want to control that aspect of your life. You want to control who's going to be managing your money and your assets and taking care of you and your loved ones and your children when you become disabled. So that's part of estate planning, and you need to have documents that take care of that and give that control to your family. The second sentence, it has to do with that after death planning. You need to have documents in place to say who's to get your assets when you die, and who's going to be controlling that, distributing those assets to your family or loved ones, and how are they going to get it. Okay, so we need to have both of those parts covered.
So this definition was really developed by the National Network of Estate Planning Attorneys, and I think it's a real good definition. I will add to that that a model of the national network is that we do plans that work. There's a lot of plans out there. I think Dan, in the preliminary lead up to this, was talking about, getting kickback documents that were not workable. We're committed to making sure that our documents work right now while you are alive, when either you or your spouse are disabled, upon your death, and really until sometimes multiple generations are taken care of through the estate, through your estate plan.
That's right. And another aspect of this too, of this definition, is we know we have documents in place that name people to handle these various roles and things for you when you become disabled and when you die. But again, and Dan's going to talk to you in a little bit about the importance of having some money or some way to pay for all these costs before you die, and then after you die, some way to pay back the estate, to supplement the estate, so that there would be something left to go to your loved ones. So that is another important aspect of estate planning. We're going to be addressing that in tonight's webinar. There are 4 types of estate plans. Okay, 4 types. And I guarantee you that each and everybody here tonight falls in one of these categories. It might be that you fall in 2 categories. So I'm going to go through and describe each of these plans with you tonight, and you're going to very clearly see which one you fall into. The first one is the unwritten plan. We don't have any documents in place at all. Okay, so this is I call this the government plan. Okay, this is where you don't have any documents in place, and so that's when the courts have to come in. They have to come in and take care of you when you become disabled before you die, because you haven't named anybody to do that. And that's expensive. That's called guardianships and conservatorships. You always have to get a lawyer involved. Everything is statutory. So the statutes determine your life at that point, and that's why lawyers have to get involved to interpret the statutes, right?
So a few years ago, I had one of these unwritten estate plans. What happened is a mom and dad died in short order. They had a farm in the Culpeper area, and their son was named as the primary executor by the court. And of course, when you have a written plan, someone's got to step forward, and the court's got to decide whether or not they're going to approve that person or not. The problem with the son is he had filed bankruptcy a few years ago, and so essentially the court allowed him to be executor of his parents' estate, but they put all kinds of conditions on his service. One of which was that he had to find a lawyer who would have to check off on every single expenditure he made. And so, and I was shocked. He came to me. I was shocked at how much activity he had to come down to our office and have us review it and approve it. So we complied with the court order. It took us literally, I think by the time we were done, 300 to 400 hours of work. We gave the guy a pretty good break, but even then our fee was in the neighborhood of $45,000. For probably less than 10% of that, the parents could have done an estate plan and saved all of that expenses. And plus, there was conflict in the family, and I don't think we resolved a lot of the conflict, and it just went on and on. Now, I completed my job, but the damage was done at that point in the game. So the lesson here is, if you don't have anything in writing, that's the least best scenario, and it's the least favorable, and it's not where you want to be.
Right, that's exactly right. It's horribly costly and a terrible burden upon the family too. But unfortunately, it is the most common estate plan. We saw that graph I showed you earlier. 2/3 of people die without proper planning. So that's the unwritten plan, where no documents are in place. You're completely at the mercy of the court system and the government. So now we're going to talk about the traditional will plan. The traditional will plan. Now, keep in mind the will, that's one of those after death planning documents. The will does nothing for you before you die. Keep that in mind. But at least the will gives you control over, some control over your estate after you die. You're going to be able to decide who's going to be settling your estate, who the executor is going to be. And then you can, hopefully a properly drafted will should waive the bond and should waive a lot of the costs that the statutes would assess upon the executor. So you want to make sure the will provides for your executor to be paid and things like that. The will names who the beneficiaries are. So with the will, you get to say who gets my stuff when I die. If you don't have any document in place, then the statutes say who gets your estate when you die. So you get to name who your beneficiaries are, and you can decide how your beneficiaries receive their inheritance. We're gonna, and you keep in mind, the will still has to go through the government supervised probate process. But at least with the will, you're able to control the major decisions and aspects of that process, as well as reduce the cost.
A few years ago, I had a lawyer client who passed on, and this just shows you another example of how improper planning can lead to just such tragic results. And he had a girlfriend on the side. She didn't even speak English. I don't even know if I don't think she was even a U.S. citizen, but she got herself appointed executor of the estate. And I represented the wife and the family, and we spent almost 3 years regaining control of the entire estate, and we really could only finally pull it off by paying this girlfriend a fairly large sum of money, and then she resigned as executor, and then the wife and the children were able to take over. But that's just so traditional will, you're making that very critical decision of who's going to be in control of your affairs when you have passed on. It seems simple enough, but without it, it causes just a huge amount of problems. The same thing with guardians. And if you don't have minor children, disabled children, you probably have children or know somebody who does. Anybody in that category needs to have a traditional will at minimum to make sure we have guardians appointed for minor disabled children.
That's exactly right, Jim. So the very important part of the will is you get to decide who's going to be taking care of your children, minors or disabled. If you don't have this covered in the will, then this is an uncovered part of your estate plan, which has to be decided by the courts and the government. If we do a will package for you, we're going to recommend that you have these other documents, the before death planning document. So as I said, the will is only relevant at your death. That's your after death plan. You still need to have your before death plan documents. So that's going to be the financial power of attorney, where you name someone who's going to be able to manage your money, your income, your assets. The medical directive, otherwise known as the healthcare power of attorney. This is where you name someone to manage your medical decisions when you can no longer communicate to the doctor yourself. The medical directive will have the living will, otherwise known as your end of life decision. That will be embedded in the medical directive. So you get to decide what you want to happen to you when you're at your end of your life. So the decision's not made by your relatives or a family member or, God forbid, the hospital. So you get to decide your end of life decision in this medical directive. Now, if you're married, each spouse will each have a will, a financial power, and a medical directive. So there'll be 6 documents for married couples here. So we can add to your medical directive what I sometimes refer to as the Catholic protections. 3 simple statements in your medical directive. The first, that you desire that your agent follow the teachings and practices of the Catholic Church when making decisions for you, medical decisions for you, and especially when it comes time for your agent to authorize the withdrawal of artificial life support. You want them to uphold the teachings of the Church. The second statement, you want to have the sacrament of the sick performed, and then the final statement that you desire your funeral to include the mass of Christian burial. Now, you don't have to have all three. You can tell us if you just want a couple, or you can pick and choose, but we like to call these the Catholic protections, and we can certainly add them to your document.
We now add a fourth one called the apostolic blessing, which I hadn't heard about, but apparently this is a special blessing that will, get you right into heaven. But it's a fourth provision we add. I would say today, Sonia and I had a discussion about a lady who is afraid of getting the COVID-19, and she does not want to be put on a respirator machine if that happens. And so we're trying to work with her to build her documents around being able to do that. But if she's a Catholic, we want to make sure that whatever we put in the document isn't contrary to Catholic teachings. And what this does is will allow whoever makes those decisions for her, let's say she's in a comatose state and the doctor wants to put her on a respirator machine, so the medical agent can contact a priest or something and say, is this morally okay? Is this consistent with Catholic Church teachings? And then, not that the priest would make the call, but the priest would give advice as to whether or not this is morally correct or not. So.
That's right, Jim. And thank you for mentioning that fourth statement. We can certainly add that as well. This is a nice PowerPoint diagram of a husband and wife will package. Not always, but most of the times, not always, the husband will name the wife as primary beneficiary, and the wife will name the husband as primary beneficiary in each of their wills. And then their wills will name their children or other beneficiaries as the contingent beneficiaries. So we have the estate flowing to each other. Normally, a lot of times, I'm advising clients, if the case is appropriate, if a husband and wife is going to use a will to keep all their assets jointly titled during their lifetime, so that when one spouse passes, all the assets will just automatically go to the surviving spouse and not have to suffer through, the probate and have to pay the probate costs or the probate burden when the spouse wanted the other spouse to get that asset anyway. So normally, a lot of times the first will won't be used. It'll be the surviving spouse's will is the will that would be going through the probate process. And eventually, after the surviving spouse passes, then the beneficiaries, their children, will be the contingent beneficiaries. We see here too that those disability documents, so you see down on that right-hand corner, when you're using a will, that just speaks at death, that handles that after death planning. So we still need to have those before death planning documents in place, the financial powers of attorney and medical directives. Here is an example. We tried to fit all of the stages of the probate process onto this one page, but it was very, very difficult. So it's a little small writing. But as I said before, even if you're using a will, the will has to go through the probate supervisory process. But with the will, you're able to control and handle all of those major decisions with the will. But the will still has to go through this probate process. And for a long time in my career, all I did was process wills through the probate process. So it takes about 2 years in Virginia, Maryland, and DC for a will to make its way through this. And it could take longer. I mean, we've heard the horror stories about some wills being tied up in probate for 5, 10 years or longer. And that's because, Henry Apps, who created this chart, he used to say that if a case ends up in one of these side boxes, then that's a holdup. And so you never know what's going to happen once you file that will. You don't know who's going to file a claim against the will and, just hold up the process, because the will is a public record and claimants can make claims and the will can be contested. So do you have anything to add on that, Jim?
Yeah, so Henry Apps, who put out this page here, published The Living Trust, which was a best-selling book. I think it's still around. Henry has been deceased for several years now. And Henry and I were actually pretty good friends. Henry would come out here to Virginia. He was from the West Coast, and we would put on seminars in Northern Virginia, Charlottesville, and so forth, Williamsburg. And this was his kind of this was his idea of showing the complexity of probate and why, even though you might have a will is still going to take you into probate. And as Sonia said, you know, if you go straight down the pipe, there's no problem. There are probates. Some of you maybe have done probates where it went fairly smoothly. But if you get off into the left or the right, you can get stuck for years, literally years. In fact, 25% of probates are still going 3.5 years after the person died. So this is what this chart is trying to, what Henry was trying to show with this chart.
Right, and especially if you have a complex estate, you know, you've got trust you're going to set up for, you know, minor beneficiary or disabled beneficiary or problem children. You know, you may not want to use a will to settle your estate because the more complex the will is, then the more likely, you know, it's going to be held up because the court is involved in interpreting the will. And, you know, and then because they have to do that, that holds up the process. So especially with those complex estates, and if obviously if you have a very large estate, you would not want it to be subject to the probate tax, because the probate tax is assessed on is a percentage of the value of the assets going through probate. Okay, the third type of estate planning, we're getting through these. I'm sure you're all figuring out which one you fall in right now, right? The poor man's estate plan. We like to say this is a poor way to plan. So this is where you don't have a document in place, but you put people on your assets, thinking that when you die, that asset will automatically flow to them. Of course, provided they survive you. You know, you run the risk that they could die before you, and then you're back to square one, right? So here we have, you know, I see this a lot with spouses. After the first spouse dies, then the surviving spouse gets all worried that now the children are going to have to go through probate, right? And so mom, surviving spouse, she'll put son on her house. She'll quit claim deed over to son and make him a owner, partial owner. Or she'll put daughter on the bank account and make her owner of the bank account. And she's thinking, okay, you know, I'm going to equal this out and make sure every kid gets somewhat of the same value. That's really hard to keep track of, by the way. But the problem is when you put your children on your assets like this, you are exposing that asset to your children's problems. So if your son is going through a nasty divorce or has got creditors after him, those creditors are going to come looking at that house or that bank account and saying, aha, you know, here's an asset now we can go after. So now your asset is going to get tangled up with that. All right. So you don't want to do that. That's very risky. Or you might make your child the beneficiary, you know, on the asset. But then, you know, once your child receives it, if they receive it, you know, they may not receive it. Maybe they've got creditors coming after them. So you're really just, you know, leaving that asset to their creditors. So we highly discourage this type of a planning process. Jim, did you want to elaborate on this? Because I know that you.
Well, I'll just give you a little war story, and there's so many of them. People try to plan their estate. The first thing that should be obvious is that this is a very complicated way to plan your estate, because you've got joint ownership arrangements, you've got transfer and death arrangements, you've got pay on death, and you have beneficiary designations. But let me just tell you, a few years ago, I had a Maryland field agent whose mother had died. The dad was already deceased. The mother left by way of beneficiary designations a fairly significant amount of money, and then thought that would solve the problem. Well, the problem was that when she died, the rest of her estate that went to some other of the children was bankrupt, and so some of the children were recipients of I think life insurance and retirement plans, and they made out like abandoned. And then the other children received their share through the intestate proceedings, which was bankrupt, and they got nothing. And they tried to get the people that got a lot of money to kind of shift some of the money to them. And of course, then you got gift tax issues. But anyways, the the kids that got a lot of money were refusing, and which was their legal right to do that. And so it was causing a huge rift in the family that, you know, I think is going on to this day. So anyways, there's so many ways that these poor man estate plans, what the person's trying to do here typically is they're trying to settle their estate on their own without having to do a will or stuff like this, and it ends up causing more problems than it solves.
Well, that's right, because you really can't control all the contingencies and what's going to happen. And so it really can drive you crazy trying to keep it all dry. And you see families are ripped apart when you do this type of a plan, because some child inevitably always ends up more with than another child. And you can see that fighting going on. But there's a better way. You know, there's a better way. You know, going through a will or going through a trust and then having your trust handle it and settle it and provide for those contingencies is a lot better. Keeps a peace in the family, I like to say. So the fourth and final estate plan type is a living trust. And I'm kind of partial to the living trust because it, if drafted properly and handled properly, your life will never have to, you know, your assets, the trust covers before death and after death. So, so you would never, you know, never have to go to court or maybe even get an attorney involved, you know, before you die or after you die with the settlement of your estate or the handling of your estate before you die or after you die, because your trust provides for all that. So we see here that the trust provides for that before death planning. When you become disabled, your trust names a trustee to be able to manage all the assets and take care of you and pay your bills and your family and loved ones when you become sick before you die. So we have that overlap covering the before death, and then after death, the living trust serves as a substitute will. So all the assets of the living trust will be settled in the privacy of the death trustee's home, the privacy of the death trustees and your family's home, and never filed with the court. The living trust is not a public record, not filed with the court, and you keep that privacy that we also desire. Because the living trust is a private document and is not subject to the scrutiny of the court, the scrutiny or the interpretations of the court, then you can get more complex beneficiary planning. So that's why I had said before that if you do have, you know, disabled children or waywardly children, you know, spendthrift children, and you want to develop maybe a lifetime trust to hold their inheritance, you probably wouldn't want to do that with a will, because the will expose that, you know, it's a public record for all to see. Plus the will, the government may want to continue to manage the trustee of that lifetime trust through the life of the trust, and that could be very costly and burdensome.
So let's just take the first one. We could talk about all of these the rest of the night, but let's just say conservatorship. Conservatorship occurs when people have not done adequate financial or, estate planning, and as a result, during periods of mental disability, they need to have someone who has legal authority to carry on their affairs, from something as simple as paying bills and taking withdrawals from the bank to something more complex like selling real estate. And people who are caught in this case, these situations, have to have a conservatorship proceeding. It requires two lawyers, one representing the disabled person and one representing the person who wants to become the conservator. So you're paying two lawyers, and that's just the beginning of your nightmare. After that, then you have to do annual accountings to the Commissioner of Accounts, who can overrule decisions you make. And these accountings are not simple little things. You've got to document everything you do. The Commissioner of Accounts can overrule your decisions. I've even had Commissioner of Accounts pull people into court for contempt of court for not doing things that the Commissioner of Accounts had thought appropriate. These conservatorships go on and on and on. Very good for the lawyers, not good for the people who are having to be the conservatorship. The living trust avoids all of that. Everything in the living trust stays out of the court's hands, and saving literally tens of thousands of dollars with a fairly simple document to avoid these conservatorships.
Yeah, that's right. And I love the format of our living trust, Jim, too, because, you know, the National Network does such a great job. The National Network, of which Jim is a member, and we get our documents from. Article 4 of our trust provides additional guidelines to the disability trustee on how you want to be cared for during that period of your incapacitation. And it speaks to things like you're telling your disability trustee that you want to stay in your own home for as long as you possibly can when you are disabled, and that your trustee has the authority to make that happen by using trust assets to pay for people to come into the home, do the cooking, cleaning, shopping, and things like that. So you want to make sure that your trust does cover that before death planning, the disability planning.
Yeah, that Article 4, by the way, is about, I don't know, about 10 pages long. So it gives those left behind when you are mentally disabled good, clear guidance as to how you want your affairs to be handled during periods of mental disability.
That's right. That's right. And that, like I said, the living trust is great for disability planning. It's better than a financial power of attorney because the trust actually owns these assets. We're going to talk more about in just a moment about how the living trust works. Now, our living trust package documents, if our law firm does a living trust for you, then you're going to get these documents. You'll have your living trust agreement, but you're also going to need a financial power of attorney. And the reason why is because there are some assets that we all have because of the special, unique nature of the asset we can't put into the trust. We can't make the living trust the owner of your Anthem Blue Cross Blue Shield health insurance card. We can't make the living trust the owner of your Capital One bank card. Okay, so when you become disabled and incapacitated, the financial power of attorney, whoever you name as disability trustee under your living trust, you're likely to name as your attorney in fact under your financial power of attorney, so that your attorney in fact will be able to do things like file your tax return, right? Contact the Social Security office. So we still need this financial power of attorney for these things. The financial power of attorney does die when you die, but all of your assets are in the trust and then are settled through the death trustee. But the financial power of attorney necessary during life. Medical directive, otherwise known as the medical power of attorney. You still need this document because this document doesn't have anything to do with managing money, income, or assets, but this is the document where you get to decide who's managing your medical decisions when you cannot communicate to the doctor anymore yourself. Okay, and this is a document that we would, if you wanted to, we could add the Catholic protections to, and we have your end of life decision mentioned in this document also. The pour over will is only going to be necessary if you fail to put an asset into your living trust before you die. Oops, you forgot to do it, right? You didn't want to go to the DMV and change the registration on your car. I mean, I get it. So the pour over will is there. Now that one asset, that rogue asset, still has to be probated through the probate process, but your pour over will ultimately name your trust as a beneficiary. So at the end of the day, the court will want to order the executor to pay that rogue asset to your trust. The pour over will is also important if you have disabled children or minor children, because the will is the only document that the courts look to see who did you want to be the guardian of your children. So we still need a pour over will for those two reasons. Now, if you do a living trust with our law firm, we are going to help you get your assets into the trust. We're not going to leave you high and dry. We're helping you. We'll do the deeds for your real property. We'll get all your real property into the trust. We'll get all your household furnishings, tangibles into the trust, by the way, which is just a 2-page document to get your household furnishings into the trust. It's just a general statement by you that you're putting those assets into the trust. But we help you. Plus, we give you a letter you can give to your bank and other really important documents to help you go to your banks and financial institutions to get those assets into the trust.
Okay,
Jim,
so just to let you know, 20-minute notice.
Okay, Jim. Do you want to add some color commentary to this one?
Nope, you did a great job there.
Okay. So the living trust. What is a living trust? Well, there are 3 parties to a living trust, and guess what? You are all those parties. You're the grantor, you're the trust maker, you're the beneficiary, and you're the trustee. And that means during your lifetime, you're in control of all of these assets. I like to say the living trust it's a vessel to hold your personal estate for you, right? You still own these assets. These are still your assets. You own, operate, control them the same way you always have. And sometimes I say the living trust is like your alter ego. It's just a mirror image of you. So when you put your assets into the trust, it's like the same thing as transferring assets from self to self. So these are still your assets. You're in control. You're the only beneficiary. The benefit is when those bad things happen, when you become disabled, the trust names a disability trustee to manage the assets and take care of you when you're sick. When you die, the trust names a death trustee, synonymous to executor, distributing your estate to the people you want to receive it and how they receive it.
So at just a little historical note, at common law, these kinds of agreements were outlawed because you couldn't be all 3 parties in a contractual arrangement, which is what a living trust is. But every state in the country, including Virginia, has done away with that common law and allows people now to create a trust, even though they're the only party. It's like you're entering into a private contract with yourself, which is authorized by state law.
Right. Yes. And the Constitution of the United States, we still have the ability to make contracts. So that's exactly what the living trust is a contract. This is an example of what you can expect your documents to look like if we do them for you. We give you 2 sets of originals of your documents. So whether you're going with a will package or a living trust package, you're going to get 2 sets of originals of those documents. One set in a flat envelope and another set in that nice red binder. Now the red binder, I call the red binder the working copy because there are other important information in the red binder for you and your family and your trustees. Like, for example, if you're using a living trust, there's a place in the binder for you to keep track of a list of all the assets you're putting into the trust. The red binder also has your funeral and your memorial instructions and other important information like a summary of your plan to give to your loved ones. So I think we do a fantastic job. And I really love the binder because the binder is a talking point, you see. And a lot of my clients will have annual meetings with their families and their trustees, and they use the red binder as their talking point and go through that to describe their estate plan. Asset preservation living trust. So remember when I told you that the living trust was just a mirror image of you? It's just your alter ego. It's a vessel to hold your personal estate. And so during your lifetime, you know, if you have creditors, those creditors can take those assets because these are your personal assets. The living trust holds your personal assets, you see. So during your lifetime, you know, your creditors can take them. Now, after you die, the living trust can provide creditor protections on your assets for your beneficiaries, right? So that your children's creditors can't take the assets. Now, this is a diagram of a married couple joint living trust. And here we have when the first spouse dies, the living trust can provide creditor protections on a portion of the assets. On the decedent spouse share of the assets can be protected from the surviving spouse's creditors. Okay, so if the surviving spouse later on has to go into a nursing home, and we know what those costs are, they're catastrophic costs, then those nursing home creditors or any creditors cannot take the assets of these sub-trusts that were established to hold the first to die spouse's assets. And then when the surviving spouse ultimately passes away, then these assets can go to the children and to their loved ones. Other types of creditor protection trusts that we can put in your documents are marital trust for surviving spouses, for children, inheritance protection trust for adult healthy children, common trust for minor children, small little children, general needs trust for minor children, spendthrift for waywardly kids that we have problem children going on, a lifetime trust. If you really have some problem children and they really don't trust them to get their inheritance at all, you need someone to manage it for them for their life. That's what we're talking here. Special needs trust. If you have a child that's receiving government aid, then you want to talk about using a special needs trust to protect the inheritance from those government creditors.
So we pride ourselves, this is probably, if you can go back, sorry, this is a bewildering list, to be sure. One of the things we pride ourselves in is directing you to what we believe to be the appropriate trust and giving you the reasons why that trust will fit well with your situation.
That's right. That's right. Here's a picture of Jim Seidel, Attorney Seidel, with his son Jimmy. And Jimmy is a special needs kid. And so Jim Seidel is very, very familiar with the documents that are necessary to protect special needs children's inheritance from those types of creditors. Jim was fortunate one day. Dan had invited Jim out to his yacht and for the day. And no, I'm kidding. I'm kidding.
Thank you, Dan. Thank you.
Extended care and catastrophic illness. Okay, so here we're going to be talking about, nursing home costs, extended care, and how expensive that can be. And I'm going to turn this over to Dan Garrigan to talk to you about what I had mentioned before, that, there's only so much that we as estate plan lawyers can do with documents to protect your assets from your creditors. During your lifetime, your assets are up for grabs for your creditors, unless you do something extreme like give away all your assets to, a different type of a trust, and we won't go into that tonight. But so it's so important that you have some other thing involved that's going to help protect your assets from being eroded from extended care costs, and insurance works very well for this. So I'm going to go ahead and turn it over to Dan so Dan can explain to you more about what types of insurance products the Knights of Columbus offer to protect before death and after death.
Okay, well,
hey Dan, I'm sorry. Before you start, can I ask Sonia some questions on what she covered before we jump into insurance?
Well, we're going to have a question and answer period at the end, if that's okay.
Oh, perfect. Okay.
Oh,
Perfect.
okay.
yeah, all I was just going to say was, look, there's to any of these programs, are you going to fund them with your own savings program? People will say, oh, I got all this money, great, and congratulations that you've saved all that. Are you going to just go ahead and give the either the funeral home, or you're going to give the nursing home or the extended care people all this money that you've worked up for? So the big thing is that there are programs within the Knights of Columbus to make sure that for basically pennies on the dollar, you don't have to lose everything that you've worked so hard for. Remember, what we're looking at is replacing what is lost. Okay, that's probably your time with your family, either through death or it's time because you're now disabled. So that's the important thing to kind of take away from all this. None of this is going to happen if there's no money in the bank. Simple as that. And why spend all this time and effort when you can get it relatively cheaply to make sure that all your dreams come true?
That's right. And so through the Knights of Columbus, if you you're entitled, you and your family are entitled to these reduced premiums, or I can't really speak to that, but I know that there's some really great deals out there that you can only get through the Knights of Columbus. So we really highly encourage you. Now, my husband is a Knight, and Jim Seidel is a Knight. As such, I can tell you that our family is really enjoying these insurance products, and we use them to supplement our estate plan, and we do encourage you to look into that as well. Planning for veterans and active duty military. We do have a lot of clients that are in the military. So we have the ability through the National Network of Estate Planning Lawyers, we can do multi-jurisdictional documents, because if you are active duty in the military, you don't know, what state you're going to be a resident of when you die. And so, we've got a plan for that. And Jim, I wanted to toss over to you because I know you do a lot of this work.
Well, I'll just give you everybody one war story. This happened really only about 6 weeks ago. I had done a military member, 3 years ago, multi-jurisdictional case. He was assigned to the Pentagon and then got transferred to a Maryland station. So he was changing states from Virginia to Maryland, and he called me up kind of in a panic, and he was worried about, well, now do I have to change my documents? And typically, by the way, you would at the cost of, $1,700 because you have to revise almost all the documents. But I said to him, no, your document's multi-jurisdictional. It goes with you wherever you go. You could have multiple stations during your military career, and you won't have to update your documents every time. So it's a huge benefit. And at the same time, he'd also, by the way, had he had an additional child. And I said, well, it's always good to have a child put into your documents, but it's not necessary. Our documents already automatically build in afterborn or adopted children and afterborn or adopted grandchildren. I encourage clients to come back and change their documents when those things happen, but you don't have to. Legally, it's not required. So he was able to have additional children and change the jurisdictions where he lived for absolutely no additional cost. And the phone call, we didn't charge for that phone call, as we normally don't charge for phone calls from people who have just quick questions like that.
That's right. So exactly right. Now, businesses with estate planning. We have a lot of clients who are running businesses. And, the thing is about businesses, if you're running a business, then you are at an increased likelihood that you're going to be sued more frequently during your lifetime than somebody who's not running a business. That's because you're out there every day, constantly interacting with the public. So if you are running a business, we're very worried for you, and you should be too, that those business creditors are going to try to take your personal estate, and so it may be, depending on what type of business you're running, it may be that you want to take advantage of some statutes that Virginia offers, most states offer, that would provide you with personal liability protection. Okay, so just simply by registering your business with the state, you can protect your personal estate from the creditors of your business. So that's something that we do quite frequently, very regularly. Jim, did you want to add something on that? Because I know you do a lot of this work also.
It's just that if anyone listening in here has a business, please talk to us, talk to somebody about the various options you can have as far as planning your business. I was reading today in the Bar Journal about a landlord who was sued by his tenants, and they were to the tune of, it was just a huge verdict of like $1 million for things that really should not have happened. But anyway, so I think we someday we're going to put on a separate webinar just on business planning, but we want to just whistle on this.
That could take up a whole webinar all of its own. So we'll keep you posted on that one to come. So a little bit about our process. I know that you might have some questions about, what is the process with the Sido Law Office, and, what's their fee arrangement, and how much is this going to cost, and all of that. So we offer a 2-hour introductory meeting. There's no fee or obligation to you, and that's where you have the opportunity, you and your family have the opportunity, you and your spouse or you yourself, to sit down with one of our experienced staff, a paralegal or an attorney, we'll go over your personal, what's going on with you personally. Okay, this is where we, get down to your customized plan, because everybody's different. I always tell my clients, I never know who's going to be walking in the door at the initial meeting. I never know if it's going to be, I kind of know if it's going to be a married couple or a single person, but I never know what's going on with them, second marriages or, lots of children and all of this. I never know. And so I really get down to the nuts and bolts of what's important to you and what's going on and what would be the best plan that's, suitable for just you and your family. So there's no charge for this. And at that meeting, we will quote you a fee. Now we do flat fees. So you're going to know what the fee is going to be from the start, and it rarely changes. I mean, sometimes, you know, if it turns out to be, they might change, but normally, once you say, Jim, that it's usually the flat fee is you know what you're getting into. I wanted to, and I know there's another slide that talks about the planning process, and I'm going to get to that in a moment because I want to talk about the second meeting and the third meeting of that process. But if you like what you heard tonight, if you're interested in any of this, feel free to call our office. You know, here's the telephone number, the email. We will give you a copy of today's slides. We'll give you the introductory booklet, which is just a wonderful resource there. Give you a 5% discount on our fees, and you can certainly sign up for that 2-hour free, no obligation meeting with our office. Let's see. So again, Dan Garrigan, who is here with us tonight and who is the host of this webinar, here is his contact information. I encourage you to contact him. He will give you that booklet that is such a wonderful resource, and here, you know, schedule a meeting with him. Now, if you fill out that booklet that they have in advance and then give it to him in advance of the meeting, then he's going to be able to really hone in on what insurance products are going to be necessary for you and your family, or just to meet your, suitable for you and just to meet your basic needs.
And Dan has this great, if you look at the bottom, the Gen book, where you can just get on that website and just sign up for an appointment. I don't mean to be stealing his thunder, but that way you can get right in and chat with him if you want to do that.
Yes, we have all types of technology available to help you through this process. The estate planning process. Now, this is what I was wanting to get to. Well, there was this study by this Northwestern University that 5 to 6 hours of planning is going to save you and your family literally hundreds of thousands of dollars in cost. So, you know, not just in the money savings, but also that burden, that terrible burden that would be put upon your family if things weren't planned out properly. So here we go. So we talked about that initial meeting, 2-hour meeting, and this is where we will tell you a plan that we think is best for you and your family. We will tell you that at the very initial meeting. Okay. We would discuss the options between using a trust or a will, so you can decide which is best for you and your family. We'll quote you a flat fee. And then at the planning meeting, which is the second meeting, so you have the second opportunity, 2 hours right in front of a lawyer to go over the plan. I call the planning meeting decision day. This is the day I want my client to come to the table. I want their decisions. Who's going to be their medical agent, right? Who's going to be the backup medical agent if that first one can't serve? Who's going to be the guardian of the children and the backup? You know, how do they want their estate distributed, and to whom and to how, and those types of things. That's decision day, the planning meeting. And at the planning meeting, we do require 1/2 the fee to be paid at the planning meeting, and that's when we start to draft all of those documents. The signing meeting is when we bring all the documents to you, okay? And we 2 hours long. It always takes 2 hours, maybe a little bit longer, but we go over everything with you. And then if you're doing a trust, then we will go over the homework, what I call the homework, for you to go to financial institutions to put all of your assets into the trust. The signing meeting, the final half of the fee is due at the signing meeting. And then if you are doing a trust, we do a follow-on meeting with you, a funding phone call. We'll do this by phone. And this is to see how did you do with the homework we gave you. Usually my clients take about 30 to 60 days to do the homework. We want them to put their assets into the trust and then have a nice list of those assets in the binder so that they can and go over that with their family. I encourage my clients to have annual family meetings. So we want to see that list of assets. We want to see some verification that they place the asset into the trust. So about 60 days after you sign the documents, we'll call you on the phone, and that's all included in the fee as well. One other thing too, you know, one benefit that Jim Seidel provides the clients is this a lifetime guarantee. If you ever have a question about your estate plan, you can always pick up the phone and call our office and talk to a lawyer and a paralegal. There's no fee for that. And I can't think of another law firm that I ever known. I don't think they exist that will give you that benefit. So I tell my clients, we are there for you. We are here for you, your family, and your generations after you. We care about you. We're going to be there for you. So our law firm does recommend a 3-year estate planning review meeting. It's not required. It's just recommended that every 3 years, maybe you want to sit down with us and so that we can refresh your memory to how your plan works. Make sure all your assets are still in the trust. So the 3-year review meeting is pretty important. I mean, it's pretty beneficial. Make sure that you're still happy with all of your decisions that you've made.
Yeah, if any of you listening in have current documents done by another lawyer, we'd be happy to give a second opinion on those. If that's all you're looking for, we might charge a little bit for that meeting, but we'd be happy to take a look at someone else's documents and weigh in on them if that's what you desire.
That's exactly right. Oh, I'm sorry. Yeah, so if you do sign up for a meeting, you mentioned this webinar, that you attended the webinar, then you are going to get a discount off of your fee. And I think the law firm is offering a 5% discount off of your fee. So make sure that you mention that discount. This is a picture of our receptionist, Linda Palmer. She's very, very sweet, has this nice Southern accent. We just love her to death. And so she's going to be the one that will schedule your appointment. She handles all of Jim and my calendars and everybody else on law firm's calendar. So she's excellent and you'll really enjoy her. So we have another webinar coming up. Jim, did you want to talk about this quick?
So these are Dan's working, helping us sponsor these. Our next one is St. Elizabeth's Ann Seton Council. May 28th, 7:30 p.m. Dan, you want to say anything else about that, or?
Just that we're having another one, and you're welcome to come revisit this information. But more importantly, if people that you know have not taken care of these things, that you're kind of like, I'd like to give you a subtle hint, like, please do it before something bad happens. You know, this is a great way of doing it. So.
Right. You know, I'm so sad when I do see people that do wait till the last minute and then it's too late. You know, once you lose your mental faculties, it's really too late for you. You don't have the capacities to sign your documents anymore, then it's really too late after that point. So you need to really get this done in advance. And usually these documents, you know, they last for your lifetime. You know, it's not going to be necessary for you to change these unless you have like your life-changing events, you know, like you go through a divorce or if you want to disinherit a beneficiary or change a trustee. But you really need to get these things in place, and that then you have the insurance and it's there if you need it. So I want to thank Dan Garrigan for hosting this wonderful webinar, and appreciate everybody that has logged in and to hear this. And I guess I'll just toss it back to you, Jim, to conclude, or Dan to conclude.
Why don't we take some questions and answer? We appreciate everybody's patience, but shoot away. And if you want to ask a question by chat, you can do that too. And so somebody had a question, I think.
Yeah, it was Chris. Sorry, I had to step away to get the kids.
Okay, well, Dennis Brown here.
Okay.
Go ahead, Dennis. You can go.
Hey. Oh, okay. I'm a current client. I worked with Sonia maybe 6 years ago and worked up an estate plan. And in March, I got a letter inviting me to do the 3-year review. So that's something I plan to do, but I haven't done it yet. And but it's an informative letter talking about some changes in the law that might affect, I don't know if it affects things. I never heard of the Secure Act of 2019. But I did hear about the Tax Cuts and Jobs Act of 2018 and all that. But I really appreciate having worked with you to draw all that up. And And as things change in my circumstances, then I may have to change things. But so far, it's been pretty steady. But anyway, I'd just like to say thank you.
Oh, my pleasure, Dennis. And when I saw your name come across, I was like, oh, is that the same Dennis Brown that I met with a few years ago? I guess it's been like 6 years, but I still recognize your name. But yeah, I'm so glad that you're still well and everything is going okay. And yeah, we'd be happy to sit down and talk with you about, these changes that just recently happened in our federal laws. In December of 2019, made some major changes in our tax laws. And
Right, thank you.
yeah, so we'd be happy to.
Just to add about the Secure Act, one thing the Secure Act did was it made dramatic changes on how IRAs are distributed upon the owner's death. And we can make sure that the way you have it now fits into changes in the law, make sure the IRAs, retirement plans of any sort can flow, for example, through the living trust and maximize your benefits as well as protections for those retirement plans.
Go ahead, Chris.
Excellent. Now, when we got together, Sonia, when we got together, we were at Jim Berteen's office in Springfield. But do you have a different office now that Jim is retired?
Yes, we do. And so we no longer have the Springfield office. Unfortunately, we just hated to see Jim Berteen go, but we knew he wanted to retire. But we have our Fairfax office. So we still have an office in Fairfax. And it's right across the street from the courthouse on Judiciary Drive. And if you call our office, then Linda Palmer will give you the address, and you'll want to call her anyway and schedule your appointment. But the Fairfax office is not very far away from the Springfield office. It's really just down Braddock Road, so it's close.
No, it's nearby. Well, yes. Yeah.
Unfortunately, by the way, Jim Berteen has been succeeded by even someone better, and that's Dan Garrigan.
Oh, no.
Yes.
And I think Jim would concur in that. I stay in touch with Jim, by the way. So nice to have be working with Dan.
Great.
Go ahead,
This is
Chris.
actually Chris. Yeah, so my question is, like, so when the laws change, do you guys rewrite the wills, or do you just go in and update them, or what happens there? Is it a new will generated and the old one gotten rid of, or?
You want me to take that, Sonia?
Yeah.
So when someone comes into us with existing documents, there's always two options. One is we can redo the document. Some of the documents that'll be automatic. Like, for example, this Maryland client, Maryland had passed a new law regarding powers of attorney, and it was just much easier just to completely redo the document, cheaper for that matter as well. On some of the bigger documents like the living trust, we'll talk about whether or not you want to do an amendment to the trust or whether or not we want to do a restatement. I have just the last 4 months, I've done 2 restatements of living trust because the trusts were 20 years old, and the changes in the law now is about 30 pages long. So it's easier just to redo a restatement. It's actually probably a bit cheaper. So anyways, it's either going to be an amendment to the document or it's going to be a complete redoing of the document, or what's called a restatement. Sonia, if you want to chime in, you can on that.
No, that's exactly right. So if there's been a major change in the laws, it's also going to depend on what other changes you might want to make to your document too. So it depends on how old the document is. It depends about how many changes you want to make. And if there's going to be a lot of changes, and if it's a very old document, then it's going to be less expensive for us just to do a new document for you than to do an amendment or a codicil, which, the amendment or codicil would be lengthier than the original document. So that's how we really look at those things.
Jim, Sonia, can you hear me all right?
Yep, can hear you.
Yeah, this is Tom Harger. I'm the executor for my dad's living trust, and it's probably now 10 years old and probably has never been reviewed at all. The problem at this point is Dad's in an Alzheimer's unit. He has absolutely no idea what's going on in the world or with him. So is it worth you guys reviewing it, or am I just stuck with the document as it's currently written?
I don't remember. Did we do the documents, and is it a living trust document?
Not on Dad. This is done down in Louisiana.
Okay. Well, I would, first of all, I would urge you to come in and talk to us, because we're going to have some great ideas as to how to handle your dad's situation that he's disabled. And it's possible that we're going to be able to plan, even change his plan to make it maybe so he can get away from nursing home expenses and maybe avoid conservatorships. Yeah, I would urge you to come in. And you say his documents are Louisiana documents?
That's correct.
Okay. Well, you know, that Louisiana is a foreign country. You realize
Yeah,
that?
I know. It's Napoleonic law.
And so, you know, if he's in, is he in Virginia?
Say again?
Are you here in a nursing home in Virginia?
No, he's in a nursing home in Baton Rouge, Louisiana that's costing about $9,000 a month.
Yeah. Yeah, unfortunately, probably didn't get to a guy like Dan and doesn't have nursing home or long extended care insurance.
Nope, it's all coming out of Social Security and his military retirement. And luckily, he has a little bit of set aside that it's not so damaging. We're going to have enough to cover him until he passes, but he'll be 98 this coming September.
Oh, wow.
Wow.
Does he have a lawyer in Louisiana? What'd you say about that?
The lawyer that did the trust has retired, so as of right now, no, he does not have a lawyer down there.
Yeah. Well, you know, we'd be happy to take a look at it and to see what we can do for you. We probably have, heck, I bet we have 24 cases where we have our clients are mentally disabled being handled by children. And if it's done right, you can save a boatload of money and resolve family conflicts in advance and that kind of thing.
Okay, well, I'll call the office and see about being able to
Please,
work something out to get in and for you to look at it.
yeah. Anyone else got questions? Well, we certainly appreciate the people that have attended this webinar. We're going to continue to do these, and by the way, we're fully open for business. In fact, I'm busier. I seem like I'm busier than ever right now. So we're fully open for business, and we do things we have meetings by a webinar, by a GoToMeeting. We do Zoom meetings, and we're just continuing to put out the work. So, Dan, I'm going to turn this over to you to make concluding remarks.
Okay, well, again, I want to thank everyone for coming. This is important stuff, not only for you, but for your family. Just like Jim said, nights are still open for business. And just like Jim and Sonia, I have been like extremely busy. So, which is a great thing. A lot of people are all of a sudden, it's like everything just changed in 2 months. You know, everything changed. And now all of a sudden we are all looking at a new normal. And that new normal is going to take on a lot of ramifications for the years to come. And, you know, your parents, your grandparents, I lived through the Spanish flu. I lived through swine flu. I did this. I did, you know, I mean, and I walked through snow up to here. So, but the point is that you saw what happened, or you may have known family conflicts or family things that have happened to you or friends of family, or that they could have been resolved quickly and easily by you planning and making those plans and putting them into place and and making everything legal. So we're here all to help. That's the important thing to remember. We're here to help, and we want to make sure that your families are secure. And So anyway, with that, we want to wish you all the very best. Wish your
Hey,
family.
Dan, before you sign off.
Yep.
Before you sign off, I need to ask you a question. Did you maintain your license to sell mutual funds?
Yes.
Good man.
Yeah.
We'll be
Yeah.
talking to you down. We'll be talking to you down the road after the Knights decide how they're going to do this in Virginia.
Yeah, it's what Tommy is saying is that, yeah, another tool that is now going to be available to you through the Knights of Columbus is the mutual fund program, where it's going to be just as conservative in that it's going to. I had one client that is in a council very close by yours. And he basically took out this program with asset advisors a few years ago. The last 3 months, his Charles Schwab or Merrill Lynch mutual funds, they lost 9%. Okay. His asset advisors with Knights of Columbus only lost 6%. You know, so these guys are, it's a really sharp, it's a great program that they're going to be introducing to you, and for wealth management and so forth. So I'm very excited that we're going to be able to bring that to you and your families. And oh, by the way, this is not going to just be limited to just the Knights of Columbus. This is going to be limited. I mean, this is the mutual fund thing wide open. I mean, literally can walk into a Baptist church. Hey, you want to buy a mutual fund? And I can sign them up. That's how open this is going to be. So it's going to be things are changing. So yeah, but thanks, Tom. Okay, well, anyway, wish you all well, you and your families. A lot of the prayers going. There are a lot of brother knights and their families that have been affected by what's going on, not only by the virus, but also by losing their jobs or their work has been reduced. And a lot of them are coming and using a lot of the financial programs that we have that they put into place years ago to keep them afloat. And it's all here, guys. It really is. We can really be of service to you and your families. And it's not rocket science. It's just life. We want to make sure that you save as much as possible. You're protected maximum as much as possible. And I don't want to upset your cash flow. I want to make sure that you guys. It's all about balance. And part of that balance is making sure that your documents are in place and your finances are in place. So I want to thank Jim and Sonia and everybody. We're going to look forward to being of service to you in the months and years to come. And again, be safe, be well, and God bless.
Thank you,
Yeah.
Dan.
Yeah, thank you, Dan. God bless everybody.
Jim, make sure you turn the recording off.
Okay, will do. All right.
Thank you.
Thank
Welcome.
you.
Bye-bye.
So Dan, you're doing all your visits remotely now?
Exactly. Yeah, it's a new world, and it's either by these virtual meetings or the phone. It's been it's been great. I mean, in that I've been able to. I mean, I've got clients all out in Winchester now, and then you kids, and then Alexandria, and then middle of Alexandria, and this is like the best way I can be in 5 different places during the day without having to worry about traffic. So,
Yeah.
but yeah, how